So the state of California's efforts to push the California magazine ban case out until next year was just completely dismantled. So let's talk about this. But real quick before we jump into this video, if you agree that California's ban on so-called large capacity magazines is clearly a violation of the Second Amendment, go ahead and hit the like button and subscribe. Also want to thank the sponsor of this video, which is Aventon. Aventon is an e-bike maker that has been in the business since 2011. One of their main goals is to provide a quality bike that is at a price point that's accessible to everyone. Right now, they are also running an October promotion where you can save $250 off of a purchase of 2 e-bikes, and you can do that using code BUY2 save $250. So if you guys are interested, you can go ahead and check out Aventon using the links down below. And thank you again, Aventon, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state and national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is to not provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what's currently going on in the Second Amendment realm. As I mentioned in the intro, in this video, we're going to discuss how the state of California's request for more time in the California magazine ban case was just dismantled by the plaintiffs. As you might recall, the Attorney General Rob Bonta and his office recently asked Judge Benitez to hurry up and review their request to push the Duncan v. Bonta California magazine ban case out until next March. Now, I'm not going to go through the whole procedural history of this case. If you want that, you can watch one of the other videos that I put up covering this case. What you need to know for this specific video is that this case has already made its way up through the Ninth Circuit after Judge Benitez originally ruled in favor of the plaintiffs and granted a motion for summary judgment. After the Supreme Court issued their decision in New York State Rifle and Pistol Association v. Bruin, this case, Duncan v. Bonta, was remanded back down from the Ninth Circuit all the way back to Judge Benitez, and the order was for him to reconsider his granting of that motion for summary judgment and to review this issue in light of Bruin. Now, once Benitez got control of this case, he issued an order where he set the case to be resolved before the end of this year. Again, California did not want that to happen, so they filed a new motion for Judge Benitez to reconsider that order, to reconsider his scheduling, and to give the state of California more time to initiate more discovery and to obtain a history professor and professors and historians who they believe would be able to come up with historical support for their ban on these so-called large capacity magazines. The state of California argues first that the briefing schedule does not allow time to conduct the focused discovery necessary to supplement the existing legal and historical record in this case, in accordance with what they say Bruin demands. In their motion, they also argue that a historian and professor is needed to review the historical documents in this case related to this case, and that there's going to be a lot of time that this historian needs to review all these issues, that this process is time consuming. They can't estimate how long it would take, especially because they're saying that these professors are teaching and they have breaks and all these other things. So they don't know how long it's going to take, but they believe that they should have at least until March of next year. Now, after filing that motion for reconsideration, California then filed an ex parte motion to then push Judge Benitez to quickly review their request to extend this case out until next March. In that ex parte motion, the state of California argues that if Judge Benitez does not review their motion as soon as possible, then they will be forced to have to file the supplemental brief by November 10th, which is in accordance with that original order of Judge Benitez. He said that the supplemental brief here of the state of California needs to be submitted by November 10th. And so here they're saying they want more time and that he needs to review this as soon as possible, or else they will actually have to file that supplemental brief, which is kind of like I mentioned before, them almost complaining that he set a deadline for them to do their homework. They don't want to do it. They want an extension, and they want him to review their request for an extension as soon as possible. However, in reaction to all this, the plaintiffs filed a response which dismantles all the state of California's arguments for why this case needs to be pushed out until next March. First, the plaintiffs argued that Benitez should reject the state's request to reopen discovery, which would only further delay this case. They argue that another round of facts and expert discovery is not needed in this case, which has already had a ton of discovery, had a ton of expert testimony. So their argument is that the record is completely full with everything that the state of California needs. They state that even if the state must rely on historical analogs to defend its modern magazine ban under Bruin, expert discovery is unnecessary to this court's understanding of the historical record. The plaintiffs then point to a very important fact. The Supreme Court in Bruin said that this type of historical analysis is a commonplace task that any lawyer or judge can actually perform. This is why the Supreme Court in Bruin was able to find that New York's may issue carry regime was unconstitutional, even though there was kind of a bare bones record on this issue. The plaintiffs argue that the Supreme Court did not have to resort to expert testimony from history professors, that they did not have to remand the case back down to the district court level to develop all the evidentiary record and open up discovery and get expert witnesses on the whole history of and tradition of these issues. No, the Supreme Court was able to look at the record as it stood before them and actually decide, is there a history and tradition that supports this type of regulation? And therefore, the plaintiffs argue that here too, application of the Bruin test requires no expert analysis or development of adjudicative facts normally disclosed in discovery. Rather, this case turns on legal issues that can and should be resolved by this court on evidence presented by the parties and debated in their briefings and at argument. Then the plaintiffs point out that California has completely misrepresented the language and analysis that is actually required under Bruin. In this case, and also in the Miller assault weapons ban case, California states that they are able to regulate dangerous or unusual weapons. And then the plaintiffs go on to point out that the phrase is actually dangerous and unusual, not dangerous or unusual. This distinction is very important. California thinks they can justify their ban by saying, well, these things are dangerous, therefore it's an arm not protected by the text of the Second Amendment, and we can therefore regulate them. However, the true language is dangerous and unusual. Inherently, all firearms and arms can be argued to be dangerous, and that's exactly what Scalia said in Heller. But if the firearm is in common use for lawful purposes like self-defense, then it's by its very nature not dangerous and unusual. Instead, it's in common use. It's not an unusual weapon. It's not an unusual arm. Magazines over 10 rounds are owned, sold, and used lawfully all across the US, and in fact, Judge Benitez already found in this very case that there is no historical support for banning these common arms, which again are in common use for self-defense. And this actually goes into the next part of California's brief, which they actually misrepresent once again. They try to act as if Judge Benitez in his prior ruling only analyzed this case using the Ninth Circuit's two-step approach, when in fact he actually used text, history, and tradition, which he called the simple Heller test. Then, after doing the simple Heller test, finding that this magazine ban was indeed unconstitutional, he then analyzed the magazine ban using the two-step approach, which was mandated by the Ninth Circuit, which again, might I add, was just found unconstitutional, was found invalid by the Supreme Court in Bruin. So he did both, but the state of California wants to act like Judge Benitez only looked at this magazine ban using the two-step approach, when in fact, he also looked at it using text, history, and tradition. So the plaintiffs, in response to the state of California seeking for this case to be pushed out until next March, systematically goes through their request and dismantles all of their main arguments. So that is where this case currently stands. There is a procedural battle for whether or not this case is going to get pushed out for even longer. The state of California obviously wants this case to be pushed out even longer, but we will have to wait and see what Judge Benitez ultimately decides to do. I don't think that he is going to grant the request to push this case out any longer. We saw how he reacted in the Miller case. He wanted to expedite that case. He's pushing for that case to be resolved as soon as possible. And I suspect that this will actually be the way that it happens in this case as well. But the state of California is really pushing for more time, in this case, Duncan v. Bonta. But if we get any more information, I will let you all know. Also, if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. A lot of you on my last video were asking whether or not I went to undergrad at UC Santa Barbara. And because you saw I was wearing that sweatshirt, yes, I did go to undergrad at UC Santa Barbara. I was a gaucho, and then I went to law school at Penn State. So for those of you who are asking that, yes, I did go to UCSB. That's why I was wearing that sweater. So you can ask me questions like that. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.